Next, also from California, delays in the issuance of CCW permits in sensitive places post-Bruen. Many of you in this state are very familiar with facing those delays, and some of you in New Jersey and other states are as well. And joining us to talk about this today, attorney for Michael and Associates PC is Moros. Konstadinos Moros, welcome up, brother. Thank you, sir. If you have a presentation, you can use that.
Make sure I don't mess up the stage here. So good morning, everyone. It's great to be here in my hometown of San Diego for the Gun Rights Policy Conference. Thank you, Second Amendment Foundation, for hosting. So my name is Kostas. A lot of you know me from my Twitter account, but believe it or not, I'm also an attorney sometimes. Everyone in the room might appreciate that joke except for Chuck. So while my own interest in the Second Amendment is pretty broad, as those of you who follow me know, today I actually want to talk about the specific topic of carry rights in California. And update, we now have some, a little bit. And the right to carry is critically important to me because even in the broad spectrum of Second Amendment rights, it comes out on top for me, particularly now, because now I have a toddler. She's almost 2. She's a delight, and we love to take her to plenty of places around town. We live in LA, and as those of you who also have been to LA know, it's a wonderful city, but it also is a challenged city in that there's been historical crime problems, and when I take my daughter to the park, there's a lot of unsavory characters around, and thank God nothing's ever happened, and I hope the odds are that nothing ever will happen, but I would never allow my daughter to be in danger, and California is doing their damnedest to try and take that right away from me by keeping us all disarmed. People who have gone through the process to get a permit, which has been very difficult, very trying, and have basically non-existent crime rates, yet they still harass us. So it's very important to me that good people have a reasonable path to be able to exercise their right to carry, and they be able to do so in most places, barring except places like courthouses and other places that have security. You should be allowed to carry, especially if you've gone through the trouble to get a CCW permit. So California does CCW permitting in an interesting way. While most states, I think New York might be similar to California, but most states issue on a statewide basis, we actually issue by county and city. So you apply with your sheriff or your chief of police. And what that meant before Bruen was that California had a sort of mixed result. If you lived in LA or San Francisco, unless you were someone rich and famous, you were never getting a CCW permit. It's just not possible. Whereas if you lived in somewhere like Tehama County or one of the other many rural counties, your sheriff would say on their website, yes, we have a good cause law, but if you are a law-abiding citizen and you say you want it for self-defense, that's good enough for me. And they would issue the permit, and you would be able to carry statewide, so you could visit San Francisco with your CCW, even though nobody there could carry. So it was this sort of disparate system. Bruen resulted in a sea change to that. So all of a sudden, people, even in these unfriendly counties, could apply for a CCW permit. And they did in huge numbers. Within months of Bruen, LA had, the Los Angeles County Sheriff's Department had thousands of applications in. And this sure pissed off some of our best friends like Governor Newsom, who began calling out judges by name in press conferences. This is after he had criticized former President Trump for the same thing. He began doing it himself. And he also mocked the very idea of a right to carry. He used scare quotes when he described it at a press conference as if it's not a real thing, because he doesn't believe it's a real thing. So these floodgates opened, and there were all these issuing authorities who had never before issued permits. They hadn't been set up because they hadn't done it before. So we were patient at CRPA. We wrote them letters, but we were understanding that if they were making good faith efforts, we would give them some breathing room to get set up before we started suing. And we had some great success stories. San Francisco was very tough at first, but then a lieutenant took over their CCW department who was acting, and still is, in very good faith to get it up and running. And now, although there are a lot of hoops to jump through, lots of people have gotten CCW permits in San Francisco. It's actually probably the biggest surprise of this whole effort that resulted without any litigation. There were threats of litigation, but that's okay. Water under the bridge, San Francisco. So then the empire really struck back in two main ways. The first was that they banned carry basically everywhere meaningful except streets and sidewalks. That was SB 2. And then they also made permits in the same bill much harder to get, but also not just through law, but through practices like 2-year wait times in LA and Alameda, or $1,000, and that's actually cheap now, but $1,000 expenses in cities like Laverne. Now San Jose is, I think, up to $1,500 for a CCW permit. So first, let's talk about these so-called sensitive places. In 2023, the legislature passed its Bruen response bill, which, just like New York, New Jersey, and Hawaii the year before, it banned carry pretty much everywhere. So that's parks, state parks, libraries, anywhere that serves alcohol, this hotel, for example, public transportation, banks, public gatherings, playgrounds, athletic facilities, casinos. I need to take a break here. Zoos, museums, places of worship, and I'm probably forgetting a bunch more. So most maliciously, like the other states before it, California banned carry on all private property by default if you are a person with a CCW. So it would only be legal to carry if the business had posted a sign saying carry allowed. And you can imagine most businesses, even those that are friendly to carry rights, don't really want to post a sign like that in California. It's going to scare off customers. So it was very cynical. I think my friend on Twitter, Rob Romano, called this the vampire rule because, like vampires of folklore, you had to be invited in to enter if you had a CCW. So I like that idea so much that I immediately stole it and put it in all our briefs. So this is a far, far cry from what Bruen intended. Bruen was supposed to establish a general right to publicly carry handguns for self-defense. You do not have a general right to publicly carry handguns if you can only carry on the street and sidewalk and the very few businesses that post a sign allowing carry. So we sued in a lawsuit called Reno May et al. V. Bonta, and we were joined by the Second Amendment Foundation, GOA, GOC, and I believe the Liberal Gun Club in that one. I'm sorry if I'm forgetting anyone. And we won a preliminary injunction on every category of place we sued on. FPC also filed a lawsuit that was heard with ours called Carolero v. Bonta, and they won an injunction on some of the places we had not sued on. So all in all, we had mostly nullified this effort. So then we did our briefing. Of course, California appealed. There was this whole drama about the Ninth Circuit staying, then unstaying the ruling. Well, that's a little inside baseball, so we'll skip it. And then I found out in April who our panel was that was going to hear the appeal. And guess what? It was a judge appointed by Joe Biden, a judge appointed by Bill Clinton, and believe it or not, a judge appointed by Jimmy Carter. So not exactly a dream panel for us. It was a tough break, and I think I joked with Chuck that I was going to start writing the Supreme Court cert petition that day. So if I'm being honest, though, we got a better ruling than we expected considering the panel. So we won on hospitals, churches, public transportation, which is a big one, banks, public gatherings, and the parking areas connected to each of those places. And we also won, importantly, on the vampire rule. Of course, we did lose on places that serve alcohol, parks and even state parks, playgrounds, libraries, zoos, casinos, museums, stadiums, and arenas, and the parking areas. And when I say we, I mean all the cases, because we were heard with, as I said, the FPC case, Carolero, and the Wolford case. I don't know if Alan Beck's in the room, but the Hawaii case, which was Hawaii's almost identical law. The Ninth Circuit heard us all together. But the most concerning thing the panel did on this preliminary injunction, because we do get back to go back down to the district court and try again, but the most malicious thing they did, I think, was that they upheld Hawaii's version of the vampire rule, and they did this because of a distinction in the laws under which California's law requires that you have to post a sign, but Hawaii allows any form of consent. And while I'm glad we were spared the vampire rule for now, that distinction probably isn't meaningful. So because of this egregious action, the plaintiffs in all three cases decide to pursue en banc review. And we've filed for that review. We'll see if it gets granted. It's usually a long shot. But the reason I think we might have a chance is because in upholding Hawaii's vampire rule, the panel relied on just two laws. One from colonial New Jersey that was clearly about hunting. It was called an Act for the Preservation of Deer, and it prohibited you carrying a gun for hunting onto someone else's property. So that's not really applicable to carry for self-defense. But more embarrassingly, the panel cited an 1865 law from Louisiana, and it was one of the black codes. It was a law that was, as the then governor of Louisiana would say in his memoirs, it was a law that was specifically targeted at freedmen. This was right after the Civil War, right after they had lost, and they were terrified of armed freed slaves, former slaves, carrying firearms. So they passed this law saying that they couldn't enter any private property without consent. And the panel called this law uncontroversial, which makes me hope that they just didn't realize what they were doing. We'll see. We've petitioned for en banc review. I hope they change their decision. So that is, and we also talk about reviewing other places, like we think, for example, the state park thing is ridiculous and places that serve alcohol. But for now, because this is a preliminary injunction, our main hope is that we fix Hawaii's problem, because right now, Hawaii will have no right to carry if the vampire rule is in effect, other than, I guess they can walk to the bank because the panel struck down restrictions on banks. So that's it. So we'll see about that one. So that's sensitive places. But last year, we also filed a lawsuit pertaining to the issuance of permits. So there's one side of it is where you can carry, and the other side is if you can carry. Given so many authorities have implemented unconstitutional policies, and like I said, California has this city by city, county by county system where we have to play whack-a-mole, we just had to pick someone and make an example of them. And so we sued Los Angeles Sheriff Department over their 2-year-long wait times, Laverne for their expenses of almost $1,000 to get a CCW permit, and they require a psych exam, and the Attorney General because California refused to provide any method at all for non-Californians to carry here. Again, we were joined by the Second Amendment Foundation, the Gun Owners of America, Gun Owners of California, and we were assigned to a newly appointed judge nominated by Joe Biden, which, you know, it's always tough, you lose the judge role. But we did get a partial victory here on the preliminary injunction. So this was another split decision, but the judge agreed with us that 2-year-long wait times were likely unconstitutional. Unfortunately, she limited relief to the named plaintiffs in the action, which was frustrating for us, but at least we have something established now where we know the judge at least broadly agrees with us, and we'll have to pursue broader relief going forward. Unfortunately, in dodging the Bruen analysis, in my opinion, she said that while Laverne had presented no historical record justifying its high fees, we had not explained sufficiently why the practice even implicates the plain text of the Second Amendment. So this, too, is frustrating because we believe the conduct is exactly what it was in Bruen, carrying a firearm publicly for self-defense, and we don't think we should have to spell out carrying a firearm publicly for self-defense without having to pay Laverne $1,000 in fees. Just like just like in Bruen, the petitioners didn't have to say without, you know, satisfying the special need or just cause requirement. It's a silly distinction, but now we are amending our complaint such that we can address this judge's particular concerns and hopefully satisfy her in pursuing a final judgment. But the most sizable victory we scored, as Chuck discussed when he was speaking, was that while the judge would not give us the win for now on reciprocity, because we had asked that California be forced to honor the permits of other states, she did agree with us the fact that non-Californians have no right to carry in the state was not acceptable. So she ordered the parties, us and DOJ, to figure out how this would actually work and submit a proposed order to her to allow non-residents to apply for California permits for the first time. So we went into these negotiations just in recent weeks with DOJ, and our goal was for non-residents to not have to come to California at all, because it would be kind of meaningless if you could apply for a California permit, but you would have to come here to do your police interview, come here to do your fingerprinting, come here again to do your training. That would be a right that would only be available to maybe someone who lives on the border with California and nobody else. So DOJ was, we had to give up a few things, which I'll discuss, but they ultimately met us in the middle there. People can do their interview online. You'll be able to mail in your fingerprints. And although the training was the final sticking point in these negotiations, we got them to compromise there too. And that is that because some sheriffs have approved online training courses, and remember, this is a 16-hour training course now. So you can do that online. And as for the live fire portion, DOJ agreed that non-residents can find a trainer in their area, tell their sheriff who that trainer is, and do their shooting qualification there. So the process is such that you will be able to get a permit, apply for one, and go through the process without actually coming to California, assuming the judge signs our order, which she hasn't yet, but I think she will because it's agreed on between the parties. The limitations are you have to be a member of CRPA, SAF, GOA, or GOC. That was something the DOJ insisted on. We promise it wasn't a fundraiser, but you all should be a member of all those anyway, so I don't want to hear complaints. And there were other compromises. For example, you have to choose the sheriff to apply to where you have a good faith intention of visiting. So make sure you really, really want to see Tehama or Riverside or one of those good counties. You don't want to go to LA. So all in all, while there have been setbacks, it's been a momentous couple of years for the right to carry in California, and CRPA and its partner organizations are working hard with their allies to defeat the efforts of Newsom and others who are trying to undermine the Bruen decision. Please feel free to ask any questions or say hello to me after this. Thank you for your time, everyone. I hope you enjoy the rest of the conference.